the 35A is not ordinarily a provision of the Constitution. It is the identity of the people of the state. It protects what we popularly call a state subject. It protects what now Constitution described as certificate of permanent residency. It protects employment for the people of the state of Jammu and Kashmir. It protects the right to acquire properties. Then it protects the scholarships which are available to the permanent residents of the state. So therefore, if you tinker with this provision, obviously all these protections, safeguards will automatically go, and not only that, politically also, as the legal position which stands today, the right to contest assembly elections is available only to those who are permanent residents. So when you're removing this Article 35A on whatever the ground is available to you, then it has a very serious implication for the people of the state. Apprehensions are very simple. As you rightly said it, this provision has been there, 35A, special terms from 1954. Between 1954 and the subsequent years, the 50s itself, the 60s itself, the 70s itself, some of the parts of this provision came under challenge before the court. They were referred to a larger bench, what we in our language call as constitutional benches. So they did not disturb these provisions and said that they are perfectly fine. Now today this situation is different. In 2014, first writ petition came to be filed almost, you can say, a few months before the new government took over. And as a part of design, that's how we see it, by an unknown group called we the Citizens of India. And it was followed by 4 more petitions, one after the other. Now, why these petitions were filed now? If somebody had a grievance, that grievance was available to him way back in 1954, and so was the grievance available to him now. The very fact with the change of government, these petitions have been filed, so we question the very bona fides of filing this petition. That's number one. And number two, we also feel that there are some unseen forces who are sponsoring this litigation to disturb the situation in the state, whatever situation exists. So far as the Constitution is concerned, there is a serious attempt to disturb that situation. You see, the bench is dealing with the entire 35A. Bench is not dealing with a part of 35A. I just have described the various elements of 35A, the kind of protection it affords to the people of the state. Now, if the bench decides that 35A is not a valid provision, 35A is not a valid provision, obviously then other many issues will come up. A lot of issues will come up. That the bench will have indirectly questioning the Article 370 itself. The bench will be questioning even maybe to the extent of instrument taxation itself, which we believe and which a historical fact was of a very limited nature, in the sense that the then king had only donated, or we might use the word transferred, his power in respect of 3 matters only: communication, foreign affairs and defense. So when you look to the instrument of accession, and when you look to why Article 370 is there, if the bench decides against the people of the state in the sense that these petitions are allowed, then it will make all other provisions very, very vulnerable. Many other constitutional issues will arise, and in my opinion, it will create a constitutional chaos. Which I will tell you, when you say this is gender biased, one needs to understand it. In 1927, first time the Maharaja issued the notification. It was followed by another notification in 1932. Now, at that time, when Maharaja issued these notifications, he was a law unto himself. He was a sovereign. He had the power, legislative, judicial and executive. He had all the powers in him. He was running a country. Now, as a country, the sovereign has the power to decide who should or should not be a citizen. Just like if you look at Indian citizenship law, you cannot question Indian citizenship law on the basis that the law is different in the United States of America. The comparison is totally mismatched. You have to understand 1927 notification, 1933 notification, which were given by the sovereign. It is these notifications which provided who could be citizen, who could not be a citizen. Now, these notifications are consistent with the position under international law. International law authorizes sovereign countries to decide that if a woman of that particular state marries somebody else, whether she will continue to be the citizen of that state or not. This is a recognizable position under the international law. So, therefore, when you see this, you have to see in the context of the position when these laws were made. Today, it looks very attractive argument to say that look here, if a woman from state of Jammu and Kashmir marries a person who is not a permanent resident of the state, she loses her state subject. Now, first, I must immediately tell you that though that was the law for quite some time, but a few years back, in a decision delivered by the full bench with the dissenting opinion of one of the judges, they have ruled that she does not lose her state subject even if she marries a person who is not a state subject. I don't think that what the JRL stand is that. They've already said that we are fighting for the basic resolution of the state of Jammu and Kashmir. And in their view, they find a close link between the laws relating to state subject and the ultimate resolution. Now, what is the link they find? Their stand is that in the event, at some point of time in future, if the UN resolutions will be implemented, at that time, one of the questions which will have to be answered is who are the people who can participate in the referendum? How do you identify those people who can participate in the referendum? That can only be done by those people who hold state subject. So this Article 370 provides its own mechanism. It says the Constitution of India will not apply to the state of Jammu and Kashmir. But President of India alone will have the power to make Indian Constitution application to us. He can pass orders, what we in our language call Constitution application orders, applicable to us. And while doing so, he again has the power under Article 370 to apply those provisions of the Constitution with modifications and exceptions. So therefore, when you take a look at the total number of constitutional application orders passed from time to time till date for the last 6 decades, you will find that the provisions of the Constitution of India, which have been made applicable to us, some of the provisions, not all, some of the provisions do contain modifications and exceptions. Just like Article 35A is an exception to Part 3rd of the Constitution of India, that is to entire fundamental rights.